this afternoon for the online taster placement on restorative justice presented to you by the Centre of Innovative Justice. First of all, the Centre of Innovative Justice and RMIT acknowledges the people of the Wurundjeri, Woiwurrung and the Boonwurrung language groups of the Eastern Kulin Nation, and to any other traditional owners whose unceded lands we work, study and meet from today. In the spirit of the Black Lives Matter movement, we would like to recognise the strength and resilience of all Aboriginal and Torres Strait Islander people, despite the impacts of colonisation, and we acknowledge and celebrate the significant contributions made by all Aboriginal and Torres Strait Islander people within our communities. And we pay respects to their ancestors and their elders, past, present and future. My name is Mei-Lin Chen-Yu-Mei. I am the Student Program Manager at the Centre of Innovative Justice, or CIJ. And today, for today's session, I am joined here by Open Circle, Anna and Asha, who are here today. And then from the Neighbourhood Justice Centre, I have Anita, Kwan and Rebecca as well, who is here. So just an outline of today's session. First, we will be hearing from Open Circle, who will discuss the restorative justice practices and how it interacts with the justice system. Then we'll hear from the Neighbourhood Justice Centre and restorative justice practices and programs at the NJC that apply restorative justice principles within the community court setting. And then finally, we will allow about 10 to 15 minutes at the end of the session for any questions you may have. So to start us off, I'll just hand over to Open Circle's Anna and Asha. Great, thank you.
Thanks, Mei-Lin. Now, I'm going to share my PowerPoint with you. So I always feel like I need to cross my fingers before I do this. But while I'm... Okay. All right, I can't see you anymore. So Mei-Lin or Asha, could you tell me if that's showing up now?
Yes, yep, we can see that.
Brilliant. Okay. So my name's Anna Howard. I'm the manager of Open Circle at the Centre for Innovative Justice. Firstly, I'd like to acknowledge the traditional owners of the land that, you know, most of you are meeting on today, the Wurundjeri people of the Kulin Nation, but I'd also like to acknowledge that I'm coming to you from the land of the Dja Dja Wurrung people. I'm up in Castlemaine, so I'd like to acknowledge them as traditional owners of the land that I'm on and pay my respects to elders past, present and emerging. So a little bit about, thought we'd do a bit of an introduction about Asha and myself, and I'll let Asha introduce herself and her background. But Open Circle is a relatively new service that's attached to the Centre for Innovative Justice. It offers restorative justice processes to people who've been impacted by harm. And we were launched in at the end of October last year, so we're just shy of a year old, and just when we were getting up and running, COVID hit. So I think lots of the team hasn't had very long to get to know each other in person. Lots of our work has happened in this kind of format, but we've been adapting the restorative justice processes to an online format, and I think it's going okay so far. So I'm a lawyer by background, so I've been where you are, and I've studied law a long time ago now, it feels like. And so I come to restorative justice, I suppose, as a lawyer who had experienced, you know, assisting people in the criminal justice system, but also the civil legal system as well, and probably feeling like there were real limitations to what the law could offer people as a response to when they'd been harmed. And so yeah, and I saw the justice system as actually causing a lot more harm to people as well when people went through it. So for me, restorative justice is a way for for the other outstanding needs that people have to be met, and I'm really happy to be doing this work and have the opportunity to sort of develop it further in the context of Victoria, where it's, you know, still in lots of spaces quite new. Yeah, I've been at the CIJ for about 5 years, working across a variety of different projects, but I've been at Open Circle since the beginning of this year. Asha, did you want to give a little introduction to yourself?
Yeah, sure. Hi, everybody. I can't see your faces either, but I heard there's a really great turnout. So yeah, it's great to see that so many people are interested in restorative justice, and thank you for coming to hear us speak. So my name's Asha Swida. I'm a restorative justice convener with Open Circle. Prior to coming into restorative justice work, I had a long history as a mental health social worker and family therapist. I've worked mainly in the community sector with inadequately resourced people who've experienced a range of complex harms, including family violence and sexual assault. So in this work, while we're not providing therapy, we are attempting to address harm in ways that promote healing.
Thanks, Asha. So I thought that we would, firstly, I know that lots of you in your studies cover the concept of restorative justice, so we don't want to spend too much time here, but I guess this gives a little introduction to Open Circle's view of restorative justice. So to us, it's a theory of justice focused on the harm caused by crime, but also other wrongdoing, not just crime, to people, relationships and community. And really, it's a framework for responding or addressing harm that is more than just punishment, and it moves people towards healing. And I suppose what we mean when we say restorative justice covers a range of different processes. So, you know, it's not a really fixed, the processes aren't really fixed, they're constantly emerging. But generally what those processes provide are an opportunity for people to come together in some way, the people most impacted by that harm to come together in some way to have a safe, structured and facilitated discussion about what happened, what happens next, how they were impacted and what happens next. So, you know, it's actually sort of at its core a fairly simple concept. It's about making difficult conversations possible. I thought it might be useful to talk a little bit about the kind of restorative justice work that Open Circle and the CIJ has been involved in. So I guess the work that kind of, you know, led to the establishment of Open Circle was a pilot project that was run from about 2016 to 2019 around culpable driving matters. So, you know, often matters where there'd been death or serious injury as a result of an accident. And usually where there'd been some culpability attached. So, you know, maybe the driver had been speeding, maybe there'd been drugs or alcohol involved, that kind of thing. And so our process, we accepted referrals into that program, and we offered restorative justice processes, generally victim offender type mediation. So bringing together the person responsible and the person or the people harmed. So in many cases, it was the family of someone who had died. So yeah, you know, it was, it's pretty heavy content and pretty significant grief and feelings that are being worked through these processes. But that pilot was really successful, and the people who participated in that pilot said that it was a really beneficial process for them to go through. And that is, you know, generally we'll come to a section a little later on where Usha will step you through what that process actually looks like, what a restorative justice conference looks like, and how it happens in each stage. So that will hopefully give you a bit more of an indication of what's involved. The other kinds of work that we've been involved in have been helping design restorative engagement processes. So that's where someone who's, you know, either working within or for some reason within an institution or an organisation and has been harmed, and that institution decides that they want to offer some kind of restorative response to acknowledge the harm that that person has experienced while they were in the care of that organisation. So, you know, you might be aware of the Defence Force, where they have offered a restorative engagement to victims of sexual harassment and sexual abuse in the Defence Force. RMIT, we worked with RMIT to design a restorative engagement response for victims of sexual harassment, sexual assault on campus here at RMIT, and historically as well. And so that process exists and is able to be accessed. Sorry, I've just moved you forward when I didn't mean to. Yeah, and we've also done some work with both the TAC and WorkSafe for designing similar kinds of restorative engagement processes, so within institutions. And there's lots and lots of different examples of restorative processes nationally and internationally. In New Zealand, there's a restorative justice process for people who've been harmed as a result of using surgical mesh, and they engaged in the Ministry of Health there engaged in a restorative process, so a listening circle, listening to the people who'd been harmed through the use of that surgical mesh, and then responding, you know, as the Ministry of Health sort of, acknowledging that harm and responding in a way that, you know, was beneficial to those victims. So this next slide here really outlines the difference of approach between restorative justice and traditional Western justice, and I guess it shows that you know, restorative justice is more focused on the harm caused than whatever law has been violated or committed. And it's also concerned about the harm caused to individuals and communities, not necessarily, you know, something that's been committed against the state. There's also restorative justice is concerned about repairing or addressing that harm, whereas criminal justice, the traditional justice system, seeks to determine guilt and impose punishment. And restorative justice, you know, a really central principle is that the people most impacted by crime or wrongdoing or harm should be at the centre of the resolution, whereas the criminal justice system, you know, the state almost takes that conflict off people, and they're largely not involved in, you know, determining the outcome. So in that way, RJ is quite different to the traditional Western legal system, but it can be used alongside it, and that's sort of the model that we recommend and work with at Open Circle. So while restorative justice also seeks to achieve justice, the justice that's achieved looks and feels different, and that's because the framework that it's informed by operates by a different set of principles, and it's designed to achieve different things to the traditional legal system. So this is, I guess, the way that we at Open Circle view the benefits, or, you know, the need for restorative justice, and that's because we see, you know, when someone experiences crime or harm, we see that it gives rise to these things we call justice needs, And those justice needs, you know, can really be varied. These are just some examples of, you know, what might be experienced. So someone might, as a result of the harm, have a need for voice, so that they might want to feel like they want an opportunity to talk about how something's impacted them, and for that to somehow have an impact. They might have, as a result of the harm, you know, it might have destroyed or impacted some relationships that they have. So sometimes this happens in the context of historical sex offences, you know, where it happens within a family, and it might be that an individual, a survivor, isn't particularly interested in restoring a relationship with the perpetrator of the violence, but as a result of their experience, it's fractured other relationships in their family, and they're really interested in a restorative process, offering an opportunity to restore those relationships. A person might have need for information. So, you know, I'm thinking about matters we've been involved in where there's been a car accident, and the driver has been the person with the victim who's died in their last moments, and for whatever reason throughout the criminal justice process, you know, those moments, what happened in those moments hasn't been conveyed to the family, and maybe the family has a real need to find out some information about, you know, what that loved one's last moments were like. Sometimes people have a real driving need for prevention. So I don't want what happened to me to happen to anyone else. And so, you know, they really want to be involved in something that means that that individual who was responsible, or anyone else, doesn't do the same thing. And restorative justice can provide opportunities to engage in activities that meet those needs. So I guess some people who, or victims or people harmed, want to participate in restorative justice because they might want to find out more about the person responsible for the harm. You know, sometimes understanding more about that person who's responsible makes them feel better, or makes them sort of understand their actions. Sometimes, you know, from the perspective of the person responsible for the harm or the offender, they might want to hear from the person harmed and understand better the impact that it's had on them. It might be part of their kind of healing. They might want to acknowledge responsibility, and some people want to offer an apology. And to some, it's really important that they want to work towards preventing harm from happening in the future. So, you know, themselves, you know, to be accountable, but also more broadly to stop that from happening, or stop others from making those same sort of mistakes or decisions. So that gives you a little bit around, and I should say that in the criminal justice system, if you think about the criminal justice system, at the moment we have victim impact statements where, you know, people can maybe get some kind of voice, although a lot of victims that we work with say, oh, look, you know, it's so sort of limited, the things that you can say through those statements. And so it's not, you know, it's not really a voice. Some people don't feel like it's, you know, they're not able to express everything that they want. And, you know, because of the, you know, the important rules around evidence and, you know, about preserving kind of particular rights of defendants, it means that the criminal justice system isn't able to always provide things like the information that a victim or person harmed or their family might need access to. So I guess you can see how someone can go through a criminal justice process and be left with these justice needs that aren't properly met. So that's where we come in, and that's where we say restorative justice is able to offer a process that meets those needs. But there's a few kind of underlying principles and factors that have got to be present in order for a restorative justice process to be deemed suitable, and from Open Circle's perspective, to be something that we would take on. And so I might hand over to Usha, who will take you through our Open Circle principles and way of doing things.
Okay, great. Thank you, Anna. So I'll take you through just really quickly the Open Circle principles, and then go into the stages of a restorative justice conference. So I'll go into the types of questions we ask, as well as how we assess risk and suitability. And finally, I'll outline a case study that will hopefully bring a human element to what Anna and I have presented today. So the Open Circle principles, the principles by which we work, are that the service is accessible. So participants do not have to pay to access the service. Voluntary, people only take part if they want to. So we work really hard to ensure that no one's sort of being coerced into participating. It actually has to come from sort of a need or a desire that they have for certain things to come together. It's a supported process. So program staff spend time with each participant in the lead up to the conference to help everyone prepare. And as much as possible, the process is responsive to people's needs. It's confidential. So what's said during the process is kept private unless everyone involved agrees otherwise. Beneficial. So we work really hard to make sure that the process offers benefits to everybody that takes part. Sometimes there's this idea that only the person who's been harmed should benefit, but I guess we work to ensure that everyone can benefit from it. And then finally, that the process is safe. So care is taken to ensure that no one is harmed by participating. All right, so now I'll move, if you could change the slide, Anna. So these are the stages in a restorative justice conference, as you can see. So firstly, an incident of harm occurs. In stage 2, a referral is made to Open Circle. So this can be done by a person who's been harmed, or a person who's responsible for causing harm, or a support person for either party. So we try to make it as accessible as possible there. We accept referrals for a range of harms, but to date we've mainly received referrals for traffic collisions, workplace harms, institutional harms and sexual harms. We don't accept referrals for crimes committed by people under 18 years of age and matters related to family violence, as there are already restorative justice programs covering those areas of need. Right, so during this stage, we engage each participant in initial intake discussions. We ask questions about people's hopes and concerns for the process. We also ask questions that allow us to ascertain whether people are voluntarily engaging with us, so that they're not being coerced in any way to participate. These conversations allow us to determine people's readiness and motivation for participating in a restorative justice process. So, for example, if we heard a person responsible for causing harm minimise the harm that they have caused, or not really want to be accountable, or on the other side, if we heard someone who has been harmed express a desire to further harm the person responsible through this process, like to yell at them or punish them further, we would be questioning the suitability of that referral and potentially not be proceeding to the next stage. So it's important to note that not all referrals progress to the next stage. We only proceed to the preparation stage if we're confident that Open Circle can address each individual's justice needs in ways that are safe and beneficial. So as you can see, stage 3, the preparation stage. So this is where the bulk of the work happens. The preparation for a restorative justice conference involves very detailed and nuanced and personalised work. So this stage can take from 2 to 6 months, depending on the needs of individuals involved. In this stage, we drill down quite deeply into exploring each individual's hopes and concerns for the conference and work with them to tailor a process that has the potential to deliver as many of their justice needs as possible. So some examples of questions that we ask are, what are your hopes for the meeting and why? What are you most worried about? What do you most want to say to the other person? What difference would it make to you to have the opportunity to say these things? Do you have any questions for them? How do you want to communicate with the other person? Who do you want to be involved in this meeting and in what capacity? So through asking all of these questions, we're trying to connect people to their personal skills and knowledge in responding to situations of harm. And the reason we do this, and Anna mentioned this earlier, is that we believe that the people closest to the problem will be the ones closest to its solution. So through our whole process, we aim to give choice and control back to the people at the heart of the problem. So another part of our role during the preparation stage is to increase people's knowledge and understanding of one another prior to coming together. So through the whole preparation stage, we might share little bits with each party about one another. So obviously with the full knowledge and consent of everybody involved. And this kind of sharing can really help to alleviate nervousness that people feel about coming together and also increase people's sense of safety. Managing expectations is also a really important part of what we do at this stage, so that everyone involved is clear about what we are and are not able to deliver. So an example of how we might do this is to say, you know, we can't guarantee that Mary will want to answer that question. If Mary did not want to speak about that topic, would you still want to go ahead with this process? We consider these preparation conversations to be practices of capacity building as well as building of safety for participants. So we meet with each party as many times as is necessary for them to feel ready, prepared and safe to come together. We make sure people feel clear about what will happen on the day of the meeting. We co-create a loose agenda, including topics that will be explored. We also prepare for practical details such as how will everyone greet one another? Who will speak first? What the meeting venue looks like? How will we take breaks? How will each person communicate if they need a break? Of course, throughout the process, we continually assess people's risk and suitability. So sometimes at this stage, together with each individual, we'll decide that a face-to-face meeting isn't the best way to proceed, and we may work towards an alternative path forward, such as a letter exchange, for example. However, more often than not, and once everyone states that they feel ready and clear about how the conference will run, we'll move to stage 4. So this is where we bring everybody together. So stage 4, the conference is where persons harmed, persons responsible and their support people meet face to face in a safe and neutral setting. So these conferences usually take around 2 to 3 hours, and the time is of course flexible according to people's need and tolerance. There are always 2 conveners present. Actually, there are 2 conveners present throughout every stage of this process, but definitely during the conference also. During the conference, the conveners hold space and support the conversations. However, because the preparation is so thorough, conveners usually take up very little space during the conference. So it often becomes like a flowing conversation between the two parties. The conveners monitor people's safety and prompt discussion points if conversations go off track. They also accompany people on breaks whenever necessary. So once a conference is completed, at stage 5, there's a post-conference follow-up and a debrief with every participant, just to check on everybody, see if how everyone's travelling, whether there are any further support needs they might have. So now I will dive into a case study. So this is a de-identified case study, and it's a matter that is currently active. So we've basically completed the preparation phase of this conference, and we're ready to move to conference as soon as restrictions ease. So this is because neither party wanted the conference to proceed online, so we've had to kind of stall the process a little bit at this stage. All right, so John was the driver in a road traffic accident which resulted in the death of a pedestrian, Claire, who was crossing the street. John had not been drinking, he wasn't speeding or using his mobile phone. John simply didn't thoroughly check for pedestrians as he turned right at a green traffic light. John's car struck Claire, who later died in hospital as a result of her injuries. John was charged with careless driving, and that matter's still currently going through a criminal justice process, as there have also been several delays there. John contacted Open Circle directly after our details were given to him by his lawyer. So during that initial intake conversation, which as we can see is stage 2 in our diagram, John expressed his desire to take full responsibility for Claire's death and the subsequent harm caused to her family. John's hope was to apologise for the harm he had caused and to be available to answer any questions that Claire's family might have. So at this point, we made contact with Claire's adult children, Tom and Mark, to ascertain their desire to participate in a restorative justice process with John. The family decided that they would like to take up the offer. So while they had really big emotions, as well as having frustrations with the criminal justice process, they ultimately saw the situation as a tragic accident. So Tom and Mark identified a hope to receive an apology from John for causing the death of their mother. But most of all, they were really interested in hearing about the last moments that John spent with her. The referral was deemed appropriate and we moved into the preparation stage. As I explained earlier, preparation conversations are really extensive and involved, so I'll only outline a couple of themes for you today. So in our first meeting with John, he identified feeling very guilty and worthless since the accident. He stated that he didn't believe he deserved to feel happiness and that his life was completely shattered. He used that word kind of repeatedly, that he's feeling shattered. So to us conveners, it became clear that part of preparing John for what will ultimately be a very difficult conversation was to initially assist him to reconnect with values, principles and beliefs that are important to him. So those things that guide him through life. So this type of reconnecting to values and history offers an individual a stronger platform from which to operate. And we went ahead and sort of had those conversations with John. After the initial preparation conversation, John identified that he was able to turn down the dial of shame and guilt and to start to see a clearer path forward. So as you can see, this small yet significant shift in how John saw himself and felt about himself will potentially allow him to receive the conversations with Tom and Mark in a way that promote healing. So this demonstrates the care that we take in ensuring we do no further harm, and in fact that we aim for these processes to be beneficial to everybody involved. In our first preparation conversation with Tom and Mark, they spoke extensively about their mother, Claire, and recognised that part of this process for them was about honouring her memory. We asked questions about what Claire valued and how she would feel about her sons participating in this type of process. Tom and Mark identified that Claire wouldn't have wanted John to be further punished for what happened, and that she'd be very proud of her boys for doing this. They said that her courage and generosity spurred them on to participate, and identified that the values by which they lived came directly from Claire. So Tom and Mark also thought that it was important for John to know a bit about Claire prior to the meeting, and they shared a copy of their mother's eulogy with us to sort of share them with Mark. So we're able to share parts of that eulogy, John. We're able to share parts of that eulogy with John and build upon the idea of honouring Claire through this process. And John agreed that honouring Claire was a really important step for him in moving forward, and decided that he'd like to do that by volunteering in some capacity to assist other people who've caused harm in similar situations. So that, you know, this tragic accident didn't happen in vain, that he was kind of going to give back to others. So at this stage, both parties have identified that their experience with Open Circle thus far has been beneficial, which is just fantastic to hear. You know, that even the preparation phase is a really important and beneficial part. And I'm really looking forward to bringing them together once restrictions ease, and really looking forward to sort of seeing how it goes and the benefits that they can potentially experience once the whole process is completed. Now, I have a couple of quotes from John that I'd like to share. These quotes come from an interview that I recently did with John. The interview was part of John's process of honouring Claire's legacy. So, you know, his hope was to share his experiences with Open Circle thus far, in order to assist other people, like I said earlier, who are trying to make a decision about whether or not to participate in an Open Circle process. Okay, so John said, I think after that first meeting that I came away feeling a sense of like, wow, I'm actually still John. I'm John. That's just unfortunately had a terrible accident that's happened, but I'm still the person that I am. It has made me look at things a little bit differently and not to be so harsh on myself, because if I didn't have Open Circle, it would have been a long time between anything happening, because, you know, we've had a couple of adjournments and everything. So I would have just been thinking all of that time negative, probably, as opposed to thinking some positive. I think having some of that connection with Tom and Mark as well has also been beneficial. Yeah, so that's the end of my presentation there. I hope that was interesting to have that case study sort of embody what we've been talking about.
Yeah, incredible. That is very powerful stuff to hear, that real story that you're kind of navigating as well, and just to hear about the amount of preparation that goes into one of these conferences. It's not just, you know, set up a conference, it's actually navigating and preparing both sides, which is a big part of the process. Yeah, John's story is very powerful, and you can sense even just from that story the emotions, the high stakes that are involved in a conference like that. So that sensitivity is incredible. Thank you for that presentation. I'll hold off from questions until the end, and we'll just shift to the Neighbourhood Justice Centre. So Anita will be presenting first on the Peacemaking program that is being developed and also delivered, I think, at the moment. So thank you, Asha and Anna. We'll now move on to Anita. Perfect. And you're just on mute, Anita.
Of course, I had to do something wrong. Can you see the PowerPoint, Maiden?
Yes, we can.
Okay.
Yeah.
Well, thank you very much for having us here today. Now, on behalf of us all, I also would like to acknowledge the traditional owners and custodians of the land on which each of us is currently living, studying and working, and pay our respects to their elders past, present and emerging. This is Aboriginal land, always was and always will be. Now, my name's Anita de Blasio. I'm the Neighbourhood Justice Centre Peacemaking Service Manager. Now, Peacemaking is a new restorative service which brings people together who have been affected by conflict or crime. I'm just going to take you a little bit on a journey around how we got the service up and running and the type of work we're currently doing. Okay. Now, before I continue, I'd like to also acknowledge that on my slides there is some artwork, and it is artwork from the Neighbourhood Justice Centre, created by local community members and street artists, and it's quite beautiful, so I hope you enjoy it. Now, as a community justice centre, the NJC's establishing legislation has a significant focus on simplifying access to the justice system and applying therapeutic and restorative approaches in the administration of justice. Now, when we talk about a restorative approach, what we're talking about is we're aiming to build healthy communities, increase social capital, decrease crime and antisocial behaviour, and repair harm and improve and restore relationships between people and communities. And that restorative approach really underpins our work at the Neighbourhood Justice Centre. Now, also in our recent strategic plan, the plan commits the NJC to identify, analyse and respond to unmet priority community needs. And as an example of one of these needs, the plan talks about complex and unresolved conflicts that can lead to school disengagement and harm to community and family relationships, including developing a peacemaking pilot in Yarra in partnership with a range of stakeholders. Now, that's how peacemaking fits at the NJC. We have actually had 2 past restorative programs at the Neighbourhood Justice Centre that were discontinued for a range of reasons. So I'm thinking 3rd time lucky, so I hope so. Now, what happened was in 2018, the NJC magistrate and staff went on a study tour of the USA, and they dropped in to visit the Red Hook Community Justice Centre in New York, and they learnt about the Red Hook's really successful peacemaking program. So the visit inspired NJC to look at perhaps trialling a peacemaking program at the Neighbourhood Justice Centre, and probably adapted to our cultural context here. Now, if you've got time, any of you, I'd really encourage you to get online and have a look at the Red Hook peacemaking program. There's a lot of information out there, and there's an evaluation, and it really is, I don't have the time to go into what their peacemaking program looks like, but it is just fantastic reading. Now, so once NJC were inspired to look at providing a restorative service, what they did was they engaged an expert consultant. Now, we're very privileged to have on board David Moore. David Moore's been involved in the restorative justice movement since the 1990s, and he's helped establish so many successful evaluated programs globally, and is currently the principal advisor with the Defence Abuse Response Task Force and the National Redress Scheme. So we've been working very closely with David around getting the peacemaking service up and running. Prior to doing that, of course, what we did was we ran some really extensive consultations. We needed to see if there was a need out there, and if there was, what the gaps were. And that information we've used to inform the service design and operations. Now, we conducted consultations from the end of last year to around March this year and spoke to over 50 service providers, stakeholders internally at the Neighbourhood Justice Centre and also within the Yarra community. We asked questions around the type of issues they were seeing and how they were being dealt with, and the possible gaps within the court context and within the community context, and also what the challenges and barriers would be for a possible peacemaking service. And it was as a result of these discussions, we actually identified a real need in the community. And it needed to be a service that would be able to be flexible and respond to the complex and changing needs of the conflicts within the Yarra community. Now, during the consultations, we asked stakeholders to provide us with real-life examples of a situation that that peacemaking could have dealt with. And I'll just give you an example here of one of the situations that an NJC lawyer provided us with. And it was a situation involving a few families. They were living on the same public housing estate in the city of Yarra and were from the same community. Now, the young adults from these families were really good friends, and they went out drinking together one night and got into some mischief. Now, this, what happened was the families became involved in an argument over this night of drinking and about who was to blame, who led who into the drinking, etc. And this situation actually escalated into conflict, resulting in aggressive behaviour, threats being made, banging on doors, etc. And police were called out quite a number of times. The police actually eventually took out a personal safety intervention order application on behalf of one of the family members against others, which some of the families perceived as the police taking sides, which complicated the matter even further. Later, the police actually withdrew their application and distanced themselves. The conflict escalated further and people began taking out intervention orders against each other, and there was something like, I think, 8 cross applications. At court, when everyone ended up in court, the matter was referred to mediation. However, they declined mediation. The conflict had become too entrenched. Everyone wanted their day in court, so they declined mediation and they all went off to a contested hearing at Melbourne Magistrates Court. Now, the sad thing about this situation is that the young adults at the centre of the conflict were all up-and-coming members of their community. They were all did really well at school, at universities, and were the potential leaders within this community. The conflict fractured the relationships between the young people, between the families, and really divided the community that they belonged to. Now, why would peacemaking have been appropriate in this matter? Well, first off, early intervention. We would have hopefully had the matter referred to us very early on, either by the police or community members or local services. We're doing a lot of work around having a community presence. So the early intervention really is the main point there. Also, peacemaking's very inclusive. We would have involved the young people, the family, community members, police, and we would have probably had brought together the young people on their own, had a number of sessions with them, the same with the family members and the community members, and then brought them together. We would have, peacemaking isn't just a one-off session. It can be, but more often than not, it is around engaging over a longer period of time with people. Now, that's just one example of where there was a gap for peacemaking, and we actually found that there were a number of gaps where peacemaking could be used. Now, we started developing the peacemaking framework from the information gathered during the consultations. And what we're doing is we're using an action learning approach, and we're doing this to ensure that the service is flexible and responsive to the community needs. So we're using a continuous improvement cycle of planning, doing, checking and acting. And this is so that we can just review where we're at and if we need to change our approach or our target areas. We're also a broad-based service, and we're accepting referrals from a really wide range of sources within the City of Yarra. Sorry about that, that's my dog. Gosh. Okay, so we're also, whilst the consultations identified matters that may be unsuitable for peacemaking, our first approach is to accept all referrals for assessment. And if it's not suitable for peacemaking, we refer it to the appropriate service. So we're creating really strong referral pathways with other services. We also have what I see as a toolbox. We offer a range of restorative processes that provide clients with different options to suit their needs. We use community conferencing, which explores what's happened here, how everyone has been affected, and work out if things can be made better, and if so, how. We also use peacemaking. We can use peacemaking circles, which they use at a Red Hook. And we also use conflict coaching and restorative conversations, especially in the one-on-one dialogue in preparing people for peacemaking. Now, our principles, the principles that underpin our service are from the Australian Association of Restorative Justice, which are cause no further harm, work with those involved, and set relations right. Now, what we mean by set relations right is it may mean that relationships are restored, or they may simply no longer involve intense conflict, or they may be formally ended, or they may be re-established. Now, that's the framework. Now, the types of cases we've been focusing on is we've really been trying to establish that community present, that building of rapport and trust with service providers and community members. We're focusing on multi-party neighbourhood conflict with an emphasis on public housing and early intervention. We're also focusing on conflict between young people. between young people and their family, young people at school, and also developing or establishing a relationship between young people and local police. We're also providing victims of crime with access to restorative options at any stage of the criminal justice process. As well as doing that, we're also promoting peacemaking as a way of assisting community organisations and groups to improve relationships within the group with one another, assisting communication, or just bringing them together to tackle a broad range of topics or to give them a unified voice. We're also currently in discussion with the Registry and the Judicial Registrar and the Dispute Settlement Centre of Victoria around providing peacemaking at court for the personal safety intervention order list in case in case there are matters that we can deal with that are better suited to us than mediation. Now, we actually started receiving a range of referrals during the consultation process, and we were slowly progressing those. Unfortunately, COVID hit, so some have been put on hold because people have other priorities at the moment, justifiably so. But one of the cases that I'd like to just briefly touch on is the work that we're doing in North Richmond, which is a case that is actually developed into a project. Now, as a little bit of background for those that aren't from Victoria or Melbourne, for decades in North Richmond, the community has witnessed high rates of heroin use, drug-related crime and overdose-related deaths compared to other Melbourne suburbs. What the Victorian government did was they established a medically supervised injecting room in North Richmond, and that was to address those issues. Now, the medically supervised injecting room and the surrounding safety issues have polarised parts of the community, often causing conflict, and there's been a breakdown of relationships. Now, towards the end of last year, we were approached by a number of stakeholders to discuss if peacemaking could assist in some way. So we were working with key stakeholders around how we could use peacemaking. So we're actually hoping to run a number of structured and facilitated meetings aimed at transforming the conflict into some sort of cooperation. We're hoping to reduce tensions around the medically supervised injecting room and move towards a collective understanding and a constructive action to improve the situation. We're actually starting to hold online meetings in a couple of weeks, and that's going to be to run some peacemaking meetings around reviewing previous community engagement efforts in North Richmond. And we're involving over 50 stakeholders. The meetings will involve 6 to 8 people at each session, online session, and it will be around each participant describing their key personal experiences around previous community engagement. Now, at the conclusion of this round of meetings, we're going to be providing participants and stakeholders with a summary of these collective lessons learned, and these will be used to assist with future community engagement moving forward. And it's also a way of peacemaking, building rapport with the stakeholders and community members so that we can move on to the next stage of peacemaking in the North Richmond community. Now, that's it in a nutshell. So I'd really encourage you to reach out if you'd like to know more about peacemaking. That's my email address there. Thank you very much.
Great, thank you. That's fantastic. I'm sorry. I think I'm just going to mute. Sorry about that. Yes, knowing the issues, the very complex issues myself around the MSIR in North Richmond. So that's a very knotty problem, and where restorative justice would add so much value in repairing a lot of the, I guess, harm and also the relationships in that community, which have been really fragmented over a number of issues. So thank you for your work in that area. It's a great presentation. I will now hand over to Kwan from the NJC, if Kwan is available.
Hello.
Hi, how are you?
Good, thank you. How are you?
Good, thank you. I think we've still got Anita's screen. Do you have a presentation, Kwan?
So, yeah, I do. Can you see it? I've shared it.
No, we cannot at this stage. Anita, if we could just get you to stop sharing your screen. And then, yes, perfect. And then Kwan, you might have access to it now.
Yep.
Great.
Okay. Can everybody see okay?
Yes, we can. Yeah,
Perfect.
Yeah, perfect. Thank you.
Okay, so before we start, I'd like to acknowledge that we're meeting on the lands of the Wurundjeri people of the Kulin Nation today and pay my respect to the elders past and present and any Aboriginal communities who might be with us here today. So my name is Kwan and I'm the Neighbourhood Justice Officer at the Neighbourhood Justice Centre. So a bit about my background is that I have a background in criminology and psychology, and for most of my career I have worked with corrections, both at the NJC as a case manager and at other mainstream location as well as drug court. So I'm here today to talk to you about my role as the Neighbourhood Justice Officer and specifically about a significant part of my job, which is the problem solving process, and hopefully we'll have time to go through a case study. So the Neighbourhood Justice Officer is a position created under the court's legislation, Neighbourhood Justice Centre Act 2006. It is unique to the NJC court. This role is a dedicated officer who can be present during court proceedings and is basically a conduit or middleman between the court, services and the clients. The NJO develops and facilitates collaborative processes that support the therapeutic and restorative goals of the NJC court. Now, it all sounds very fancy, but what does it actually mean in practice? So there's basically 4 functions to my role. Triage and case management means that I'm engaging with clients outside of the courtroom and then raising any kind of issues that require attention from the magistrate and making sure that they're aware of that. For example, you know, it can be anything small, such as just making sure that the court is using the right pronouns to address somebody in court. Coordination of services means that I'm making sure that any referral the magistrate makes to services are smooth and there are continuous communication between myself and the service, basically taking any information that's been communicated in court and providing that to the service. Thirdly, identifying gaps in current court practices and developing some sort of innovative and practical solution to that. And that's often done with our programs and innovation team. And lastly, problem solving process, which is basically the bread and butter of my role and what we're going to focus on today. But before we jump into that, I'd like to talk a bit about why the NJO is important in the NJC context. The restorative, therapeutic and community justice principle that underpin the NJC requires the court to play a more active role in seeking to address the underlying cause of an individual's offending behaviour than traditional court. In order to ensure that our court is still maintaining procedural justice and impartiality, the NJO acts as a gateway of information by engaging with the clients, the lawyers and practitioners such as clinicians or corrections out of court. This helps the court paint a more holistic picture of the client's circumstances and assists the magistrate in making more relevant decisions. So, what is the problem-solving process? It is basically a voluntary out-of-court process designed to bring together the client and the relevant parties in order to address the underlying cause of their offending behaviour and any obstacles they might be facing. The key event in this process is a structured meeting, which is convened by the NJO. It is inspired by therapeutic jurisprudence principles and the notion that people are more likely to make positive changes in behaviour when authority do things with them rather than to them or for them. I have lost my mouse. Hang on a sec. So this process has been operating at the Neighbourhood Justice Centre since 2007 and it's most suited to people who have a range of coexisting psychosocial issues and are at high risk of serving a custodial sentence. So the key aims of the problem-solving process is, number one, to provide the client and their support, including family, friends or professionals, an opportunity to work as a team and to generate concrete, actionable and client-driven outcomes. It is also to assist the magistrate to fulfil the judicial role by providing information and realistic solutions, which could inform the decision-making. Now, a significant difference between the problem-solving process and, say, peacemaking is that it is, whilst focusing on repairing harm, but also very action and solution focused. We're wanting to find practical outcome to the issues that brought the client before the court. So there's several operation principles that underpin the problem-solving process. It is developed during the early stage of NJC operation after consultation with stakeholders such as client services, correction, police prosecutors, in-house lawyers and the presiding magistrate. So these principles are in place to protect the legal rights for the clients who choose to participate in the process. First of all, multiple referral points referring to basically anyone could make a referral to the problem-solving process, including the magistrate, the lawyer, the client themselves, family members or practitioners such as clinicians or correction case manager. It is facilitated by independent convener and in this case the NJO. Thirdly, participation in the process is voluntary. If the client chooses not to participate for any reason, it's not going to be disadvantage. It's not going to be a disadvantage to them throughout the court hearing. And consent must be informed. So throughout any contact with the NJO and during this problem-solving process, the client needs to have full understanding of what it means for them. but also they can withdraw consent at any time if they no longer wish to participate. And lastly, any outcome that goes back to the court needs to be agreed upon by all parties that is being involved, including the lawyers, the clients, and anyone who been invited to participate in this process. So that's just a bit of statistics about who makes the referral. Generally, most referral comes from the magistrate. Okay, so when is referral made? Basically, referrals can be made for the problem-solving process at any point during a person's progress through the courts, and referral can be made several times for the same individual. For criminal matters, it is preferable that the person has already pleaded guilty or intended to plead guilty, and again, that is to protect the legal rights. During different stages of the person's contact with the court, problem-solving meeting and problem-solving process can be used to address different issues. For example, if it's during the pre-sentence stage, it might be to assist the magistrate in making decision. During deferral, it might be used to address any kind of issue that arise, such as if the person is not engaging with service. And during sentencing, it might be to kind of set up a bit of a foundation for when the person are no longer engaged with the court. And lastly, it can also be used by corrections or youth justice if they are having issues with a client who are particularly struggling with their orders, or there's an increased risk of their reoffending. So in general, if the referral came from the magistrate at court, the matter is usually stood down for some time, so I can meet briefly with the client in the presence of the lawyer to explain what the problem-solving process actually is, to make sure that they understood what's been explained to them and is capable of giving informed consent. The client will then have the option to discuss the matter with the lawyer in private and choose whether or not they're wanting to participate in the process. If they choose to do that, the eligibility criteria for problem-solving process is very simple. It's just them having to recognise that there is an issue and there is a problem that needs addressing. It is intentionally broad because we want to work with people in different stages of change, whether or not they're still very resistant, or whether or not they're ready to make changes. So one thing during the assessment that I would particularly look for is whether or not they can participate meaningfully in the process. For example, is there any major barriers for them, such as can they attend the meeting without being a substance affected? Is their psychiatric illness going to impact on the comprehension? But also the assessment process will involve the kind of establishing some sort of background information to the client and getting to know who they are. Because at the end of the day, the client are the experts of their lives, and we want to make sure that whatever process we ask them to participate in is relevant to them. And lastly, I would sit with the client and the lawyer to come up with a list of people who they like to invite to the problem-solving meeting. Sometimes the client will choose to invite family members or friends or people in their personal lives. Sometimes they like to keep things just to professionals that work with them. So the problem-solving meetings generally runs for 90 minutes. At the commencement, I would reiterate the principle that underpin the meeting, and specifically that participation is voluntary. So consent can be withdrawn at any time during the meeting. And secondly, that the discussion is confidential. The only exception to that confidentiality is if actual or threat of harm to self and others are disclosed, and when there is consensus outcome that we all agreed on and needs to be reported back to. So obviously everybody is expected to participate in the meeting, in particular the person who's been referred to this process. Again, it's a reiteration that this process is driven by them. So the problem-solving meeting follows a standardized format where everybody would go around to introduce themselves and their relationship with the client, as well as what they hope to achieve and expect of the meeting. The first part of the meeting is around problem exploration. Is framing the problem from the perspective of each participant, especially the client in question. And the second phase, it's finding commonality in the issues that's been raised. And third part of the meeting is around handing the ball back to the group and asking them what issue they collectively as a group decide to prioritise, what issue they see as the most pressing and urgent, and what can wait. And the fourth part of the meeting is around kind of gathering ideas and practical solutions to the problem that's been raised. It really focusing on the client and their support network coming up and generating ideas that will support changes of behaviour. And the emphasis is giving a voice to the individual or the client in questions and making sure that what we come up with are going to actually work for them. These suggestions and ideas are written out on a board by myself towards the end of the meeting for participants to discuss. And this will be written as simple statements, and those statements will become the formal meeting outcome. Each participant is then provided with a copy of this outcome and the meeting is closed. So the focus of the meeting varies at times depending on the individual and the dynamic of the group. Sometimes it's around really focusing on identifying specific actions that they need to take and they can commit to. And sometimes it's about helping the client work better with their support services. So we'll take you through a case study. Obviously, it's been de-identified, but in this case, our client in question is Demi. Demi is a female in her 30s. She was in custody for drug and property-related offending. The referral was made to the NJO at the time of sentencing. The magistrate was looking at sentencing her to a community corrections order and recognised that she has a lot of complexity and vulnerability. She has a history of disengaging with services and not complying with orders. She has a significant acquired brain injury, eyes addiction. She's been diagnosed with a range of mental health issues, including anxiety, depression, and post-traumatic stress disorder. And she's also been a victim of significant family violence. Her partner at the time was also in custody. He was the person who's committed family violence against her, and he was due to be released several months after her. So the magistrate recognised that this is a really critical point and services kind of need to band together and work cohesively to assist Demi. So as you can see on the slides, these are the things that have been identified as issues that Demi was currently facing at the time, collectively by by the group, and we recognise that we can't address everything all at once. So the group have decided that the most pressing concerns are her housing. So her partner is due to be released very soon, and she was no longer safe where she was living at the time. So there needs to be some sort of assistance provided to her to get a transfer of her housing. Secondly, there seems to be a lot of service who are involved with Demi who are doing the same thing. So we urgently need to define and I guess have better allocation of roles and duties. And thirdly, Demi finds it really overwhelming that she's engaging with so many services and finds it difficult to manage her responsibility, and that has resulted in her disengaging with services in the past. So and as other urgent thing to do is to establish some sort of structure for her. So here are some of the outcomes that we came up with. Number one is the outreach worker will contact the Office of Housing within the next 5 days to request expedition of the transfer for her housing. And number two, Demi will liaise with the TAC lawyer in relation to her rehab program. So allocating a specific role to a specific person. And number three, Demi will have regular meetings with her workers as follows: corrections on Monday, NDIS on Wednesday, and outreach on Tuesdays. So this outcome is handed over to the participants at the end of the meeting, and it also gets report back to court. So what happens after the problem solving meeting? Well, any actions that we've been agreed upon will be and should be followed up. Like I said, a report is providing to the court for the next hearing, including information such as who referred the matter to problem solving, who participated in the process, a brief statement of the problems, and the outcome as we saw. So when the matter is back at court, I will be in court to answer any questions that the magistrate might have. And there might be issues arise during the meeting or during the hearing that require further follow-up meeting. And that is something we would organise. But in most cases, one meeting is generally enough. So if this is a very brief overview of what the problem-solving process is and what I do. If you'd like to read into it further, there is the paper published in relation to that, so you can have a look. And if you've got questions, feel free to contact me.
Thank you, Kwan. That was really great. That was a good overview of that service. And I think what's reflected in a lot of the presentations today is how everything isn't a one size fits all, and everything really has to be tailored to each case to be effective. But now I will just open the floor to any questions anyone might have who's attending today. Feel free to use the chat, or if you'd like to take your video off or your microphone off, please feel free to ask any questions. We've just got I think just a message. Could we get the link to the article, Kwan? Sorry, we missed it. So yes, we can definitely get that link. I'll get Kwan to email me and I'll email it on. I guess not a problem. I'll direct a question, and maybe this is one to all the presenters. because I guess many of the students here have not experienced the justice system firsthand. So maybe some of the principles that you're talking about or the approaches seem like common sense. Why don't we do this anyway? Reflecting on that, can you probably explain why this is such a new and alternative way to what's currently the justice system and how it operates? We can start with Anna, if that's okay.
Sure. Yeah, so I'm really happy to talk to that. I mean, I suppose the legal system and the criminal justice system, change happens really slowly. And so, you know, the criminal justice system and, you know, court system that we see now doesn't look remarkably different from what it looked like 100 years ago. I mean, that's the reality. And actually, probably COVID-19 has made it look a lot different, a lot more different than, you know, that change of pace that's had to occur as a result of COVID-19 has been probably the most rapid and significant shift that the courts have gone through and the justice process has gone through, you know, certainly in our lifetimes, and I think, you know, possibly ever. But and so, you know, what happens is that because there's so many different agencies involved in the criminal justice system, you know, and they're quite siloed, I guess, and everyone's, you know, fairly protective of making sure that, you know, their part is sort of, you know, everyone knows what's happening, and they don't want change because that requires all these changes down the track, and they've got to train staff and da 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 da. And so, you know, there is this sort of entrenched resistance to change. And so, and I guess the other thing is that the criminal justice system isn't designed really to meet the needs of its users. It's never been designed in that way because, you know, when you think of the criminal justice system, the users, I suppose, are the people who are seen to have done wrong. And the people who've been harmed or victims are sort of aren't part of the process at all. And so we've got this system that's sort of designed around the needs of services, or, you know, the institutions that make up the criminal justice system, lawyers, judges. You know, it's not about sort of the people who are having justice done to them. And I think that there's been a shift and a movement away from that idea, you know, over the past 30 years or so, and that momentum, you know, is growing because a number of these programs, like restorative justice programs, peacemaking programs, you know, therapeutic jurisprudence programs, have been piloted and then they've been evaluated, and we've seen that they have positive impacts, and we've realized, oh, you know how we design services, like, you know, when you go an online shop for something and we design it around what makes something easy and useful for the person who's using that service. Why would we not do that with the criminal justice system? Because it's in everyone's interest that it actually works and that it benefits the people who come before it. So, yeah, I mean, that's like a snapshot response to a fairly complex problem. But I can see Anita and Kwan nodding their heads because I know that they will have experienced this too. And I suppose, you know, the final thing I wanted to say is that getting change, getting things happening in this space, being a new, you know, at the forefront of change or trying to push for a different way of doing things is really, really hard. It's super rewarding, but golly, it's hard work because most people are worried, and in the criminal justice system especially, people are worried about risk. And they think, what's the risk of if we do it this way, because it'll be on the front page of the Herald Sun. But the way we like to think of it is, what's the risk of not doing it? because we're seeing that risk playing out, you know, in our expanding prison populations, in, you know, more victims being created, and so, yeah, hopefully, I'd like to think that with the kind of expansion of these kinds of programs, and, you know, you've heard some of the really beneficial case studies today, the more that those stories are heard about, I think the more appetite there'll be for change.
And I guess adding to what Anna has said, like traditionally the justice system's designed to deal with the issue in front of them instead of the bigger picture. And I think all these programs are in place to make sure that we're addressing the underlying factors that it's causing these problems in the first place, rather than just kind of putting a quick fix on whatever issues in front of the court today.
To do is have a look at mediation. Mediation is quite widely understood these days and accepted, but if you look, it's how long has it taken? You need someone very brave, like I know Rob Hulls was an advocate of mediation, and you need a champion with courage as well, and political nous to know how to bring it into the mainstream. Yeah.
So I guess if there are no other questions, I'll just have a follow-up question on that. Yeah, how do you see this being scaled up to be applied wider to the wider justice system? Obviously there's you've all identified systemic issues with the justice system that restorative justice is attempting to address by including the victims and giving them a voice, and including the offenders. Do you see it as scalable and that opportunity? Yeah, we'll start with that.
What you need to do is make sure that the programs are evaluated. Okay, there's got to be a really good evidence base. Also, you've got to be able to show if there's a savings to it as well. You need to put a dollar sign attachment to whatever you're doing. That definitely, yeah, definitely. And I think it's a slow process. It really is winning hearts and minds. Yeah.
Yeah, it's also about education, not just to the community, but also educating the judiciary, educating lawyers, because you need them on board for those programs to work. The more people are aware of this sort of resources, the better they are at using them.
And I think that, you know, finally, if I can add to that, there are examples, like in New Zealand, where restorative justice is embedded into the mainstream. And so, you know, it's almost, the rule is that it's almost an opt-out system there. So where a restorative justice process will be offered, and if people don't want to go through that process, then they opt out, as opposed to, you know, our system where there's, you know, little pockets of it being offered as an exception. And they have a whole sort of legislation and funded system to support that. And so, you know, when we're talking about scaling something up, that's really what's required. You know, you need to invest in that kind of model of justice. And yeah, we're not there yet. But we're at the point of proving that the models work, and hoping that the next step's not far away.
Amazing. Thank you for that answer. If there's no final questions, I'll just see if anyone else does have a question. No? Okay, then well, thank you so much to Anna, Asha, Anita and Kwan for their presentations on restorative justice. I think that seeing how restorative justice is applied in these programs and through your services really kind of paints a picture of how complex and, you know, relationship based it is, and how one size doesn't fit all, and it really takes an investment and preparation to get the right results. So thank you so much for sharing your stories and those case studies. We really appreciate it. And thank you to everyone who attended today as well. Thank you so much.
Thanks,
Thank you.
everyone.
Thank you.